Any questions before we get started? All right. So when we started talking about employment law, one of the things that we mentioned was employment, for the most part, for vast majority of employees, is employment at will, right? That's a phrase that we use to indicate that employees perform employment duties voluntarily, and employers have the right to discharge or terminate employment for valid reasons. And one of the reasons that is not valid is if the employment is terminated, or if an employee wasn't hired, and if an employee wasn't given certain things that one would expect based on an employment relationship, such as the ability to work in a stress-free, discriminatory-free environment, or wasn't given a promotion or something like that based on a reason that is discriminatory, as we'll talk about in this chapter, then there are causes of action under federal law that the employee can pursue against their employer. So one of the pieces of federal law that is so very, very important with respect to not just employment discrimination, but discrimination of any form, is of course the Civil Rights Act of way back ago, 1964. And when we think about the 1960s, we understand sort of the time period that the country was going through. And again, we're talking about discrimination much more than just in the employment context. But here, for purposes of this chapter, when we talk about employment law, we're really only talking about Title VII of the Civil Rights Act of 1974, because it's Title VII that deals with employment discrimination. And the idea here is that there is a federal law that provides equal opportunity in employment. An equal opportunity in the sense that there ought not to be job discrimination based on what? Based on, under federal law, under Title VII of the Civil Rights Act, 5 different categories, or 5 different what they call protected classes. Okay, and that's a phrase we'll see come up. What are the 5 protected classes? Well, the 5 protected classes are race, color, religion, sex or gender, and national origin. Okay, it's these 5 broad categories, and we'll talk a little bit about each of these. Of course, a lot of this is self-explanatory, but we'll talk about how the statute and how the courts have sort of looked at each of these 5 different protected classes. All right, we said that Title VII deals with employment or does away with job discrimination. Well, what does that mean? Who does this apply to? And it surprises some people when they sort of read, well, Title VII applies to employers with 15 or more employees. And you might say to yourself, well, there are a lot of small employers all over the country. Does that mean that employees that work for those employers do not have a responsibility to uphold federal employment discrimination laws? No, that's not entirely true. But one thing to sort of keep in mind is when the federal government enacts a lot of different types of laws, there often is a minimum threshold of employees that an employer has to have to be subject to that law. And it's sort of a compromise, a balance. So for example, when we talked about the various laws that apply to employment situations, one of the laws that I mentioned, for example, last time was the COBRA law. Remember COBRA, when you're able to extend your health insurance? Well, it doesn't apply to employers as well if they're not over a certain size, right? So there's this notion that small employers should have a little bit more leeway. So what it means here in this context of employment discrimination is that the federal law, Title VII, doesn't apply. It doesn't mean that small employers can discriminate. There are other federal laws and state laws that apply to them. It's just that the federal law, Title VII, that carries with it much more in monetary penalties and so on, doesn't specifically apply to very small employers. Okay? So that's just the way federal law tends to work. So it applies to most employers. It applies to employment agencies as well. It applies to labor unions. It applies to workers that work for state or local governments. It applies to federal governments as well. So it's not as if the job discrimination rules only apply in the private sector. They apply to nonprofits. They apply to labor unions. They apply to a governmental employer as well. They would apply to this university, Rutgers, as a state university. So again, the scope of the law applies to most employers in this country. And what is the law intended to do? Well, the first bullet here lays it out in summary form, and it basically says that it prohibits discrimination in what? In various types of employment scenarios, such as in hiring someone, promoting someone, compensation, how much do you pay or not pay, based on if your decision has something to do with one of these 5 categories. Dismissal, meaning terminating someone's employment or subjecting someone to work rules in a way that is discriminatory, again, based on those 5 different categories. So it's not just dismissal, it's hiring, it's job terms and conditions, it's compensation. All of those things are sort of under this umbrella of terms of employment. Okay? And when we think about someone who might have been discriminated against, or someone bringing a lawsuit or filing a complaint with the government with respect to having a discriminatory practice asserted against them, we often think about, well, what is the type of discrimination? And here we do have to sort of understand the difference between disparate treatment discrimination and disparate impact discrimination. Terms that sound very similar, but stick with me and let me sort of explain the difference between these two, because this terminology comes right from Title VII of the law and the way the courts have interpreted it. So the first one is your typical case of discrimination. Disparate treatment, meaning different treatment, which is discriminatory, is where the employer discriminates against someone specific, a specific individual, John Smith, Jane Doe, right? There is someone specific that the discriminatory practice is allegedly directed at, again, based on that person's, again, coming back to those 5 categories: color, sex, religion, race, national origin, okay? That's disparate treatment. So what's disparate impact? But disparate impact is basically where the employer not just discriminates against a specific individual, but can be said to, or is allegedly discriminating against an entire class of people based on one of these different categories. And the book had an interesting example, right? What if an employer basically said, I will hire qualified individuals for this particular position, but in order to apply for this particular position, the individual must be over 5 feet 8 inches tall. Well, the last time I looked, being over 5 feet 8 inches tall is not based on race, color, religion, sex, or national origin. What's the problem? How is that something that is under Title VII of the Civil Rights Act? Yes. Typically, yes, and that's just a statistical fact. So isn't this really a roundabout way of saying we prefer to hire males in this position, right? I mean, if I just sort of asked everyone to stand up, we would find, not all, but most men would be over 5 feet 8 inches, and I would be hard-pressed to find very many females in this room that would exceed that sort of an arbitrary standard of height. So again, you start to see, I mean, no employer is going to come out there and say, we will only hire people of a certain race and so on. But could there be a roundabout way where a legitimate case can be made that the real impact here would be to exclude a certain class, a protected class, from having equal opportunity in employment? Okay? So understand the difference between disparate treatment, which is, an individual saying, I wasn't promoted, and I think the reason is because I am a woman, let's say, versus, a policy that seems neutral on its face, but actually has the impact of being discriminatory against an entire class. And Title VII protects against both types of discriminatory practices. So we'll talk a little bit about what it takes to bring a lawsuit based on Title VII, but to the extent that a plaintiff, remember a plaintiff in a lawsuit is someone who brings a lawsuit, to the extent that a plaintiff is actually successful in proving a case based on discrimination on one of these categories, what can the plaintiff hope to recover? Right? This is a civil lawsuit. This is not a criminal lawsuit. The employer is not subject to criminal penalties, but the employer is subject to civil penalties, such as back pay or reasonable attorney's fees if, again, a case is successfully proven to be one where the employer discriminated. Equitable relief. And the word equitable means what? Equitable. What did we say that word generally means? Yes. Yes, but sometimes we think of it as value, equity, and shares and so on. But here there's a slightly different legal meaning to equity or equitable. Fairness, right? So, oftentimes money solves a lot of problems, right? Let's face it. If someone has had a civil wrong done to them, sure, one of the things that they're looking for is, well, I didn't get the promotion, where is my back pay and so on and so forth. But the other thing, in fairness, that an individual that is able to successfully prove a case of discrimination against their employer is, in fairness, they're also looking for their job back or being reinstated at the position they should have been had, let's just say, that promotion been given to them or that position of seniority or so on. So this is sort of something that, again, could be given as damages, if you will, in a lawsuit where the plaintiff has successfully proven a case of Title VII discrimination, and in some cases, punitive damages. And don't think that punitive damages are criminal. Punitive damages are civil damages that go above and beyond what the plaintiff actually suffered. And when are they usually awarded by a court? Courts don't like to give out punitive damages because those are what big dollar numbers that everyone always says, well, the country's run amok, we have all kinds of lawsuits and so on and so forth. It really is reserved for those outrageous cases of intentional discrimination, where the employer, for example, has become a poster child for engaging in this kind of behavior. So yes, it is possible, but in most cases what they're looking for are actual damages to compensate someone who's been discriminated against, and potentially equitable or damages based in fairness for that particular situation. All right. Maybe one point that's not on the slides, I forget it's there or if it's not there. The other point that I wanted to make with respect to bringing a case under Title VII, and this was in the book, may not be on the slides, but it's an important point. And the point is this. If someone wants to file a Title VII case, one of the requirements under the law is that before you can bring a lawsuit, you have to do something. Anyone remember from the reading what that something is? I think I'm hearing you correctly. One of the requirements is that you have to first file a complaint with a governmental agency. And the governmental agency here that enforces this laws is the EEOC, which stands for the Equal Employment Opportunity Commission. Okay, the EEOC, it's a federal administrative agency. So prior to bringing a lawsuit, a complaint has to be filed. Now, the EEOC gets tons of complaints. They can't possibly investigate every single complaint, but the EEOC has to log in that, and they may or may not pursue it, but they have to then allow, you have to let a requisite period of time pass before a lawsuit can be filed. And that is just an administrative requirement under the law. Okay? So now let's just talk a little bit about these 5 different categories, which I said are pretty much based on what they are, pretty self-explanatory. What is discrimination based on race? Well, it's, not given employment opportunity where the reason for it, and again, these lawsuits are not easy to prove because it's an uphill battle. The burden of proof is on the plaintiff to show I didn't get the job, I didn't get promoted, I didn't get, I got laid off before someone else did, even though I'm equally qualified, if not more qualified. Those types of arguments based on the fact that I belong to a particular race, let's say, right? Or based on the fact that I happen to be someone of color, let's say. Or based on the fact that my cultural heritage is, country X or country Y, right? This is a burden, an affirmative burden of proof that the plaintiff has to show, where of course the employer is going to say, of course not. It has nothing to do with that. It has to do with X, Y, Z factors. This is employment at will. Jane X did not get promoted because John Doe is a better qualified individual. That sort of thing. So it's not as if any claim of discrimination is just taken at face value. It has to be proven. It has to be shown. And of course, the employer is going to refute that. And ultimately, it's a case based on facts and circumstances. But again, we're talking about these categories that are protected under Title VII, and the first three are pretty self-explanatory. Gender discrimination is quite big, right? Because that's where a lot of employment discrimination lawsuits and a lot of EEOC investigations are geared towards. And again, there are two genders, and we're talking about discrimination, although I shouldn't say that. I mean, we have an LGBT community, right? So we're talking, a much broader, and sometimes a lawsuit based on Title VII could also bring in other laws designed to protect other classes, state laws. I mean, we don't necessarily see a law designed in 1964 that's going to protect people based on same-sex gender issues and so on. So we're talking, the law sort of evolving in this area. But essentially, we're talking about discrimination in the workplace, not just based on someone didn't getting hired or promoted or so on, but creating a work environment where someone of a particular gender doesn't feel that this is something that is appropriate behavior. For example, prohibiting discrimination in the workplace where an employer or supervisor is taking advantage of someone. And again, this is where the workplace, especially today, where a lot of communication is what? Based on email, based on iChats at work, based on, more sort of informal, quote-unquote, conversations that people sort of just make and think that that's the end of it. Well, remember, in an employment situation, all of these records are being kept somewhere, right? So a typical employment discrimination lawsuit based on gender discrimination, to the extent that it's going forward, the plaintiff is requesting through discovery all sorts of things. I want everything in my file. I want every correspondence with my supervisor and so on and so forth. And companies are very, very, very careful these days in sort of being, conducting sensitivity training and making sure that their supervisors, managers, and so on understand that A, these types of policies are not acceptable in the workplace, and two, that everyone understands that anything that you do at work, any correspondence and so on, is something that the employer has kept a record of and something that the employer has to turn over if a proper request is made. So this is where there is a lot of litigation, a lot of some that is warranted, some that perhaps is not warranted. But be that as it may, it's a very, very hotly litigated area when it comes to gender discrimination. And the other one, the other sort of related piece of federal law is the Pregnancy Discrimination Act. And again, forbidding discrimination based on, and of course this is one gender only women give birth, right? So based on pregnancy, childbirth, again, an employer using that as a reason for not advancing someone in their job prospects because an individual decided to have a child or decided to take time off and so on. And there are other laws that come into it, but it sort of falls under the same umbrella. And again, we've sort of talked about this as well. Within gender discrimination is this notion of a work-free, a work environment that should be free of sexual harassment, right? So again, here, again, just the way the workplace is evolving. What constitutes a lewd remark? What constitutes intimidation? What constitutes, according to the courts, a hostile work environment? A hostile work environment. Obviously, someone taking advantage of somebody else in a workplace, we know obviously that is something that could be actionable under the law. But one of the things that sort of the kinds of things companies worry about is, what if there's an email going around and the email involves a off-color joke? Could that be something that could be viewed by certain employees as being hostile work environment? What if, I'm just sort of giving a scenario, a male manager just sends out a joke and the joke is of somewhat of a questionable nature and sends it to people that work for him. 20 employees, 10 people laugh, 5 people take offense, and the other 5 people don't open the email. Is that the sort of behavior that is quote unquote acceptable in a workplace? Most employers and most employer policies would say absolutely not. Going out for drinks after work and sort of, having it be a work group, having comments being made, are those somehow falling into this category of harassment, even though they may not outwardly appear to be the case, but could they, over time, constitute a hostile work environment? A lot of interesting case law. It depends on the facts. Plaintiffs have been successful as a result of it, and employers are adopting policies that sort of make them immune from these types of lawsuits by making sure that at least supervisors, managers, and so on are cognizant of it and are enforcing policies in the workplace that are far more neutral and take this kind of behavior out of the workplace. So very, very interesting. Because again, the key words here is, could the circumstances have created a hostile work environment? And again, a hostile work environment to one person is not a hostile work environment to another person. People have different sensitivities. People have different notions of what is acceptable or not acceptable. And what the courts essentially have to do is, what would an objective person have taken it to be? And most often they come out on the side of, ultimately policies and behavior in the workplace ought to be far more neutral. And create a open environment for everybody. But again, a very, very evolving area of the law. And as I said, same-sex harassment, again, we're not just talking about male-female, it could really be a same-sex harassment, could also be violation of Title VII. And again, how does an employer, we're looking at employment law, how does an employer guard against these types of lawsuits, these types of complaints, right? You have a company of 50,000 employees. It's not possible to, directly supervise everybody, right? Depending on the size of the employer, it's very, very difficult. Ultimately, it comes down to policies and procedures, and one of the things that employers have done is, have they exercised care? Do they have policies in place? Do they have, a code of ethics? Do they periodically conduct training in the workplace and so on? Have they made policies clear that this type of behavior is not tolerated? And to the extent that something is brought to the attention of the appropriate people at the company, do they take immediate and stern action with respect to that kind of behavior? Those are the types of things that employers have with respect to being charged with a violation of Title VII based on sexual harassment or something like that. And whether or not the plaintiff failed to take advantage of preventive or corrective opportunities provided by the employer. For example, if someone feels that there is a hostile work environment, did they say anything? Did they go to human resources and say, I feel uncomfortable because these jokes are coming into my inbox. I don't find them funny. I don't think this is appropriate. Did they do any of that? Did they speak up? And if the employer is never advised, then how could they possibly take any action to readdress, or did they immediately go to a lawsuit? Right? So again, very, very, very factual. So there are things that the employer can do to protect itself, and there are things that the employee should be doing before jumping to, the step of, well, I'm filing with the EEOC and so on. I mean, there are corrective actions that can be taken internally before we move on to that step. So we've talked about gender, we've talked about race, we've talked about color, we've talked about national origin. There is another category, right? There's a fifth category, and that is discrimination based on someone's religion or religious practices. So also protected under Title VII. So what is an employer's responsibility, right? Obviously, no discrimination based on the religious views or the religious practices of an individual. And one of the things that Title VII basically says is that an employer has to sort of underline this or sort of remember this phrase, reasonably accommodate. Reasonably, we love the word reasonable in the law, right? Reasonably accommodate religious observances, religious practices, religious beliefs of employees. I mean, that's sort of a loaded kind of term, isn't it? Reasonably accommodate. So, for example, a lot of religions have a day of Sabbath, right? And so, for example, if an employee, because of their religious observances, does not work on a particular day or needs to take time off, is an employer required to give that employee that time off day in, day out, every week? The knee-jerk reaction might be no, but could you make a case for maybe, right? I mean, isn't the workplace changing? Doesn't it really depend on what does the employee do? I mean, what do, as most of you are out in the workforce, and most of you will make it out in the workforce, a lot of us work from home on Fridays, don't we? Or one day out of the week, or 2 days out of the week, and we find ourselves to be somewhat even more efficient because we're not commuting and we don't have to stop by and talk and chit-chat with everyone. We're actually getting a lot more work done and so on. But all those jokes aside, depending on what position the employee holds and the fact that there is already a flexible work schedule, could the employer have reasonably accommodated this employee to take a half a day on Friday or something like that, right? But what if the position of the employee, I'm just sort of making up the position. What if the position of the employee is a toll booth collector, right? Is that the kind of job that you can do working from home? Kind of not, right? That makes it difficult. Well, could you still accommodate that employee by having someone else cover a shift on Thursday afternoon or whatever the day might be? Again, what is reasonable accommodation is very much factually based, but the law requires the employer, if possible, to reasonably accommodate an employee if it is a religious belief that is observed by that particular employee. Okay. One of the things that is not protected is under Title VII is that religious organizations can discriminate and hire people only of that particular religion. Well, that makes sense, right? I mean, you can't force, for example, a place of worship of a particular faith to say you have to hire anyone that applies for that job. I mean, if you're hiring a minister or hiring a rabbi or hiring an imam or something, obviously you need someone of that faith. So, I mean, Title VII recognizes that depending on what the job is, there are certain practices that are going to, on their face, appear discriminatory, but they're really not. So yes, religious organizations can hire only people of a particular religion. Everyone with me so far? Any questions? All right, let's talk a little bit about, so we've talked about, well, here's what employers are expected to do and not do under Title VII, right? Now, to the extent that an employer finds itself on the other end of a lawsuit as named as a defendant because they have been accused of violating the rights of someone in one of these 5 protected classes, what are some of the defenses? What can they argue that they didn't do or did do based on Title VII to say that they were not, shouldn't be found liable for damages under Title VII? Well, the types of defenses include the following. And most employers, legitimately sometimes argue, look, the reason for me selecting employee X over employee Y was not because employee X belonged to a certain class of race or religion or something like that. No, it had to do with the very reason that we hire people. We want to hire people that are the most qualified for this position. And it was based on merit, right? It was based on their work, their qualifications. And sometimes what employers are arguing are soft skills. Right? It isn't the fact that they both had, college degrees from the same school and GPAs that were kind of similar or something like that. Well, one just performed better in the job interview. One to us seemed like a better fit within our organization. Or the fact that this position requires supervising, a lot of different people and the cultural sensitivities and so on, we felt were better embodied in candidate Y versus candidate X, and it had nothing to do with the fact that candidate X belonged to a protected class, right? Now, you could argue that, and then you could find an email through discovery where someone says, we're not hiring X because of that reason, right? So, there's sometimes a smoking gun. People, let's face it, there is discrimination that exists, but oftentimes really is, a matter of showing that, hey, yes, on its face it may look like we chose X over Y, but really the reason for it was a completely neutral reason. So that, again, we're talking about what often happens in litigation is proving your case, right? But remember, plaintiff has the burden of proof, the burden of showing that employment discrimination, to the extent that it existed, was based on one of these 5 different categories. Can employers still have a seniority system? Meaning, person who works here the longest gets to have a promotion, person who works here the longest gets the, regardless of necessarily someone's qualifications or things like that. I don't think it's a great policy, but I think it's a policy that a lot of employers have nonetheless. And sometimes, we talked about collective bargaining in unions last class. Sometimes it's written into, someone works this many hours, this many years, they get paid this much, and so on and so forth. So to the extent that an employer can say, our policy, and we, by the way, we follow this policy, and it's a neutral policy, it's based on longevity or seniority, and, so the reason why employee X wasn't promoted has nothing to do with the protected class. It has to do with the fact that we hold on to this archaic way of doing business, and that's our right as an employer. So again, can you say that it wasn't discrimination, but it was based on a neutral policy? And the other reason on the slide that's sort of highlighted here is a bona fide occupational qualification, meaning a real occupational qualification. The acronym here is BFOQ. That's easy to remember, right? It just rolls right off the tongue. The good old BOFQ, or BFOQ, a bona fide occupational qualification. So what does that mean? This means that the employer basically says, yeah, I discriminated. I did. But I did it because it was a business necessity. And by the way, this defense does not work with race or color. Does not work. You can't say you can't use that defense. But for the other 3, you could. Yes, I didn't hire X, Y, or Z because of their national origin, because of their gender, or because of their religion on purpose. Why? Because it was a business necessity. I couldn't hire someone in that class. For example, the employer is running a gym, and they need a bathroom attendant. It's a women's gym, let's just say, right? I don't know, if I joined a gym and I'm, using the showers and stuff like that, I wouldn't want a male attendant there, right? So, you can see that, yes, that is gender discrimination, but that type of a position, it's a business necessity that we will not, says the gym, hire a male. right? But on the other hand, there are people that are swiping in IDs, there are people that are personal trainers and so on. Sure, I don't think that's so much a business necessity, but for certain positions, employers could argue that based on at least 3 of these protected classes, we may be able to, quote unquote, prefer and only hire people of one gender for certain positions, or hire only people of certain religion. Again, I gave the example of, well, churches will normally only hire people of a certain denomination to work in certain positions at the church. Why? Because how could you, practice that religion if you have no background, or if you don't even observe that religion, right? That is a bona fide occupational qualification. Okay? So yes, there are defenses to Title VII, again, if you look at it from the viewpoint of the employer. All right, this chapter is not just about Title VII, even though much of when we think about employment discrimination is based on Title VII or the 5 classes, but there are other forms of discrimination, shall we say, in employment law, and we'll talk about a few more. So we're moving on from Title VII, and we're moving on to the Equal Pay Act, right? Do the same work, get paid the same amount. All right, I see eyebrows sort of going up and so on and so forth, but let's talk about what equal pay requires, right? Equal pay basically says that both genders, and again, it's not men or, it's both, should not have pay discrimination, and here I mean that should be paid an equal amount in compensation, benefits, and so on, based on equal work, regardless of gender, right? So what it does, it prohibits disparity or differences in pay for jobs that require the exact same skill, the exact same effort, the exact same responsibility, and very similar working conditions. The problem with this is, a lot of laws, black and white, okay, but when you put them into practice and look at it from an employer's perspective, we're no longer a society or an economy that is based largely on manufacturing jobs, right? It's not like a large segment of the economy is working on an assembly line or something like that, and everyone's doing exactly the same thing. From an employer's perspective, if I'm hiring accountant A and accountant B, it's not always the exact same thing, because the portfolio of clients that someone is working on could be somewhat different. Their responsibilities, there could be some supervisor, so the employer can, yes, I got paid $20,000 less than my person, my colleague who's at the same level, let's say. So the employers, are really struggling with this, and a lot of large employers, in terms of when they have pay grades and things like that, they have a range, and they have to kind of justify why X gets paid perhaps a little less than Y. For supposedly having similar years of experience, for supposedly having the same job title, and so on and so forth, because of this notion that if they are, quote unquote, doing the exact same job, then under the law, they should be making the exact same salary. Right? So again, words in the statute and practical day-to-day doesn't, it's always, or not always, but oftentimes a disconnect. Yes? Interesting. So the question, yeah, and we see a lot of these types of statistics, don't we? So the question is, there was recently a report that showed that male nurses got paid on average more than women. Now, when we think about nursing or education or careers that typically attract more females than they attract males, not that there's any, reason why that should be, but it is. Perhaps more flexibility, whatever the case might be, more of a caregiver type of a situation. But and a lot of people would say, well, those statistics speak for themselves, right? And and you have to sort of wonder if I don't know what percentage of males are in the nursing profession, but let me just pull out a number, 15%, and that number might even be too high. statistically, that just does seem a little out of whack, but if I was going to look at it from the lens of the other side, I might say, well, we just talked about women, and I think we can categorically say this without me offending anyone, women are the only gender that give birth, right? That's scientifically true. Well, along with that sometimes comes a notion that some women do step out of the workforce, take time off, raise their children, get them up to preschool age or whatever the case might be before they go back to work. And even if they do go back to work, they're working part-time or whatever the case might be. So one of the arguments on the other side might be, well, if you go in and out of the job market and so on, that hurts a little bit from a compensation perspective. And that could explain why the disparity might be. Yeah. Sure.
And he, when he works there, a lot of the women will actually ask him, like, oh, you're taller. Can you get me this? You're stronger. Can you, carry
Can you help me with that patient? Yeah.
I'm not saying, that justifies it, but I think it's, funny to see, kind of how it works and how,
The dynamics in society work. And could an employer want to hold on? They've got a staff, if I'm in ER and I've got a staff of, I'm running the department. Put yourself in the employer's shoes. Right? And again, that's what sometimes you have to sort of look at. I mean, laws that look great on their face, but on the other hand, I've got 15 RNs on my staff. I've got 2 males. It's desirable for me to hold on to them. For example, even from a cultural perspective, some of my patients prefer male nurses. And yes, statistically, I want to hold on to them. Can I just pay them a little bit more so another hospital doesn't steal them from me, so they won't look. Is that good enough of a reason? And one might say, well, but that's discriminatory. They don't do anymore. But on the other hand, is that a discriminatory reason, or is that a valid business reason to want to hold on to those couple of guys that you've got on your staff? Yeah.
I think you're looking at it from supply and demand.
Sure. Absolutely. But then again, you look at it from the other point of view. But wait a minute, why am I being punished for my gender? Why are you assuming that I couldn't? A female nurse. Imagine me 5'10", and why couldn't I? I'm equally strong. So again, these are not black and white issues. They are real issues that we all struggle with. Did you have a point? Before I.
She mentioned
Okay. Yeah, and it is supply and demand. And I could take that same argument to the education profession. I go into my daughter's elementary school. I think there's one. We do see a lot of male educators at the high school level for sure. Some at junior high. Forget it in elementary. And the schools are thrilled because, again, children learn a lot sometimes from a male educator even at that age, and the schools are bending over backwards to the extent that they can to hold on to the few that they have. So understand that but if you take out those types of professions and you look at just the accounting profession or the or any type of a profession in those kind of areas where you're talking about male and female ratios being somewhat equal, why are there disparities? And that's where we sometimes see these lawsuits and so on. So again, in theory, we should have equal pay for equal work. What are the types of things that would legally justify a difference in wages? Again, we start to see the same sort of things. Seniority, right? Now, remember I mentioned this notion of, statistically, women drop out of the workforce more and come back in, the back and forth. Well, in doing so, they let go of seniority. And if seniority is one of the reasons why people make more money or get promoted more, well, then that's just a neutral sort of a thing. And the employer is going to be able to justify its differences in wages. Merit, again, the reason that John got promoted instead of Jane was because John, part-time went back to school and got a certification that Jane doesn't have. That is helpful to have, so again, that could be an employer defense. Quantity or quality of work. Yes, you're assigned the same duties, but John happens to do those duties a little bit better. Again, that's a very subjective sort of a thing. And employers have to be careful in hanging their hat on something like that. Any other reason other than gender, and that's sort of a catch-all. And my question to you is it enough to say I want to recruit and attract more males, and that's the reason I'm paying I don't know. Employers make those arguments. Here, to the extent that the plaintiff has met its burden of proof of showing I got paid $20,000 less for the last 3 years, now the burden of proof is on the employer to show that the reason for that is a legitimate reason why there is disparity. Plenty of lawsuits out there. Plenty of very happy plaintiffs' lawyers taking them on, and plenty of very unhappy employers having to defend these types of lawsuits. And oftentimes we see them as class action lawsuits, right? I mean, there are a number of retailers out there that have been the subject of class action lawsuits because they're arguing habitually over time. I won't mention any names, but a certain low-price retailer is almost always on the receiving end of these types of lawsuits. All right, we can go on and on. Let's talk about the next area where there is allegedly discrimination based in the employment scenario. So we've already talked about the 5 protected classes. We've talked about equal or unequal pay. You know where we're going to go next. We're going to go to ageism, age discrimination. And again, this is federal law. ADEA, not to be confused with the ADA, the Americans with Disabilities Act. Here we're talking about age discrimination in Employment Act. And what's the magic age at which someone can argue that they've been, quote unquote, discriminated against? It's on the slide, but I'm not putting it up yet. 40. That's young, by the way. I mean, but that just happens to be, it's an arbitrary cutoff. Right? Because the notion being that as people advance in their careers and they reach a certain age, they're kind of expensive to have around, right? So, an employer says, well, I can keep this 45-year-old on my staff, but on the other hand, I can hire 2 junior associates and get double the work for the same amount of money that I'm paying my 45-year-old, right? What is that? If that's the reason, that's age discrimination in employment. So, prohibits age discrimination practices, and the only people that can file a lawsuit or a complaint with the EEOC based on age discrimination are employees over the age of 40. Okay, that's a cutoff. You can't be 39, you can't be 25 and say, it works the other way. I'm discriminated against because of my young age. It doesn't work that way. This is really designed to protect those, I'm not going to say old, I'm just going to say those over the age of 40. Okay? Again, we're talking about same things in all employment decisions, not just whether or not somebody was hired, but also whether or not somebody was promoted. And whether or not, how much money do they make, compensation, or any types of employee benefits. Are their benefits being cut because they cost more medically? Right? Can't do that either. That's age discrimination. Again, age discrimination is permissible, is justifiable legally where there is what? A bona fide occupational qualification reason. Let me give you an example. Many people want to serve their community and want to be firefighters and police officers. You can take the exam. It involves both a written exam and a physical exam. But guess what? There's a cutoff age. You have to be a certain age when you take the exam, and if you're not that age, you can't serve. Isn't that age discrimination? The legal age in New Jersey is 35. If you're 36 years old, you cannot become a police officer or a firefighter. And you might say, well, wait a minute, 35 is old or 36 is old? What's the reason? How would you articulate a reason for that? Because it's permissible. Well, that's really the thing. It's not looking at today. It's looking at what is the average career of a professional who's going to be in this kind of a demanding profession, right? Police or fire, for example. 20 to 25 years is typically. So if someone comes on the job much after 35, we're talking about them serving beyond the ages of 55 and 60. That's when the problem begins. So yeah, today a 45-year-old is fit, great. 25 years from now, the 45-year-old is going to be 70. Now, it's just a function of the human body. So yes, that is courts have said, statutes have said that is a bona fide occupational qualification, and it is okay to have, not every state's going to have 35. It could be somewhere around there. That is okay. That you have to be a certain age before you can join, let's say, the police force or the fire squad or whatever the case might be. Okay? And one of the other categories that we're going to sort of round out this chapter with is, what about those with disability, right? We know about the ADA, we know about the Americans with Disabilities Act, and we know that, when we think about the ADA, we think about restaurants and movie, we even think about, colleges and universities. I mean, I'm talking about physical disabilities, for example, having ramps and things like that. And we know that those with sort of emotional and, cognitive difficulties are also protected and so on. But what about disabilities where someone is applying for a job? How does the ADA accommodate that? So here, employers and again, providers of public transportation and so on and so forth must what? Accommodate individuals with disabilities. So if you have someone who has a disability, and remember that disability is really quite broadly defined. Some disabilities you can see because they're physical. Some disabilities you cannot see. I mean, someone could have attention deficit disorder. Someone could have, schizophrenia, for which they're on medication. Someone could have other types of mental illnesses and so on. But let's say you have somebody who is qualified to do the job. They're a qualified individual, but also happen to be living with a physical or a mental or an emotional disability. What the ADA says is, prohibits discrimination against an individual who has a physical or mental impairment that limits a major life activity, but the individual can do the job. Okay? And here the employer has to be very, very careful. You have someone sitting in front of you, perhaps that maybe, you're not sure whether or not they are. One thing that the employer cannot do is inquire about the disability. You can't say, well, I noticed that you're speaking with a little bit of a lisp. Do you have some sort of a speech? Can't do that. And again, part of it is just sensitivity, and part of it is that this will come back, you may just be concerned. You might say, well, you're sort of waving a little bit. Is there some sort of a neurological? Can't say that, can't ask it. What you can do in a job interview is assess that individual's qualification for the job, right? And then we sort of talk about, well, what is the employer's role here? What can or cannot they do? Remember when I talked about religious discrimination under the Title VII, I used the phrase reasonable accommodation. Well, reasonable accommodation comes in here as well. The employer's duty here is to reasonably accommodate an individual's disability if it does not cause what? Undue hardship on the employer. And again, this becomes a very factual situation, right? What if someone has an obvious physical limitation? And let's say the employer has 50 employees. But the problem is that, they don't have ramps, they don't have wide doorways in their offices. It's a cramped space. And in order to hire this individual, which they have no problem doing, they would have to modify their space. They would have to move their offices. They would make sure that the workplace is accessible. Right? They would like to accommodate, but one could argue that this could not be reasonably accommodated without causing undue hardship. So So one could say that, yes, employee X did not get the job because they were in a wheelchair, but on the other side, the employer says, it wasn't a problem with the disability, and we agree that the individual is qualified as the individual that we hired, maybe even more. But in order for us to accommodate this individual, it would constitute undue hardship. Good point. Say someone loses their vision while they are working for an employer. Braille. Right. Again, I look at that through the lens of reasonable accommodation, undue hardship. But what if the accommodation would have to go far beyond Braille? The fact with someone with visual impairment, depending on how much loss of vision there might be, there have to be other physical safeguards that have to be adopted, such as putting handlebars in places. I mean, again, I'm thinking about a tiny little accounting office where, there's paper everywhere, there are desks the individual, it would be hazardous for them to work there because without sight, you could fall, you could injure yourself. You can't even take stairs down. You may need to put in, a lift or something like that. And, if I'm renting my offices, how could I do that as an employer? So discharging that employee, is that based on a violation of the ADA, or is that a legitimate, and do we come back to employment at will? Very, very factual. And again, we've sort of talked about this undue hardship. Employers are not obligated to provide accommodations that, again, impose undue hardship. It's not that it's impossible, but it is really not something we can ask an employer in that situation to do. But again, if we're talking about a multi-billion-dollar corporation, that's not going to fly. Because they already have to be ADA compliant, right? So here, again, who is the employer and what constitutes undue hardship? And again, we don't have to become experts in what kinds of conditions are covered under disability. Most things are, most medical conditions are, but there are certain things that are not. For example, temporary impairment caused by illegal drugs and alcohol is not going to constitute a disability under the ADA that has to be accommodated. So again, you have to sort of see, first of all, is it a disability that the ADA recognizes? And if so, do we have a qualified individual with a disability? If we do, can we reasonably accommodate and not have it be an undue hardship? So again, there's a multi-step process involved here. This next one is a new category, a new law that was enacted in 2008. It's called GINA, the Genetic Information and Non-Discrimination Act, right? We like to call everything by an acronym. This is GINA. It's a relatively new law because, again, as science is evolving, one of the things that sort of became known and why the law was enacted was employers, because of the fact that they provide employee medical coverage, were getting information. Maybe they were doing surveys, for those of you that are on the workforce and so on, you complete a wellness survey. What's your blood pressure? What's your, sugar level, blah, blah, blah. And by the way, is there a history of X, Y, and Z in your family? Does someone carry a gene for blah, blah, blah? You don't carry the disease, but you carry the marker for it, and you disclose it because you want to be upfront about, you want to get the care, you want to take the preventative measures that you can. Well, is it so unthinkable that some employer tags that information and says, wait a minute, if our employee X actually contract this illness because they have a marker for it, my God, that's going to cost our health plan millions, because this is a rare blood disorder or something like that, or something as simple as a marker for breast cancer or something like that. Could someone have used that information, this genetic information, as a means of making employment decisions? Whether or not you're going to keep that person, whether you're going to promote that person, what kind of benefits are you going to offer them? Now, under GINA, employers have to wear two different hats. They either don't ask for this information, or if they do, they better make sure that they don't see it or use it in an improper way. You could still do it and manage your healthcare costs, but outsource it to a vendor where you don't see it and you're not going to be called upon to say, well, you never promoted, or you were having a layoff and you laid me off because you found out that I carry a marker for something and you violated my rights under the Genetic Non-Discrimination Act and so on. So again, so this is not just employers necessarily doing something on purpose. Now the world of employment law is very, very complicated because you have to navigate these laws in a way where you almost say, hey, I know GINA applies to me. I don't want to know about all of those wellness services. I don't even want to be in a position where I have to defend why I let an employee go because maybe there's something in their wellness service that leads them to be at a genetic risk for something. And the very last thing that we'll quickly talk about, because this is a topic that deserves a lot more attention, and from time to time it's the topic that I've assigned for our group presentations and so on, and that is affirmative action. Affirmative action is pretty much gone in employment law. It was something that was, this notion of giving job preferences to people of certain color, people of certain race, and so on was pretty prevalent after the Civil Rights Act was passed. But although affirmative action policies still are enforced in, for example, education and so on, with respect to employment, it's very, very rare. And then it really is very narrow. Because the issue these days by some groups is, well, there's now the notion of reverse discrimination, and so on. So the point I'll quickly make about affirmative action is it's very, very limited here today in 2015 if we're talking about affirmative action in employment, right? There are very sort of few entities that would say, well, if we have 15 positions, we have to give 10 positions to someone of a particular race or someone of a particular national origin or someone of a particular color or something like that. A policy of the past to sort of bring more diversity into the workplace, but not something that is true, 50, 60 years out from the civil rights legislation that brought it about. The last one I want to sort of quickly make is great. Employees, as an employee, I have all of this protection. I have, the ADEA, I have the ADA, I have Title VII, I have equal rights, and I know I can file a lawsuit, and I know I can, if I feel as a plaintiff that I've been wronged against. But here's the thing. What about the fear that if I do so, if I argue that my employer that I could get fired, that they could make my life miserable? Protection from retaliation, right? So federal law also prohibits employers from retaliating, meaning taking adverse or action against an employee that basically filed a discrimination lawsuit, and things like firing them, demoting them, harassing them, or things like that. That in and of itself is a violation, and it kind of brings us to the only case that was in this chapter, and this case made its way all the way up to the Supreme Court in 2011. This is a Thompson versus a North American Stainless Limited Partnership, and the question here was, does Title VII, this was a Title VII case under the Civil Rights Act based on, I think it was gender discrimination, permit third-party retaliation claims against an employer? And the only way to sort of answer that question is to know a little bit about what happened in this case. All right, I've been doing a lot of talking. I'm tired. What happened in Thompson?
Okay. So Thompson, he's a guy, and he had a fiance named Goldberg for this company.
Right.
And his fiance filed a sexual discrimination claim against NAS.
Right.
And NAS, instead of taking action against her, they fired him. And he
And they're not married. They're engaged, let's say. Yeah.
So the court was basically trying to figure out if he could file a claim.
Third party. Right. They didn't do anything to her.
Yeah.
Right.
But the court said that yes, he is. At first, he wasn't allowed to. But
Lower courts, yeah.
He appealed, and they said yes.
I mean, it went all the way up to the Supreme Court. And the issue, the Supreme Court is not looking at the facts, and maybe, just maybe, he was fired because of some other reason, right? Maybe. We don't know that. So this case is not about, necessarily about the facts of the case. The question really is, could a third party bring a retaliation claim? And the Supreme Court says yes.
And they even said, because technically hurted him, hurt her.
Absolutely.
She can file a claim
As well, right? They both can. And again, filing a complaint is one thing, proving the case is another. So the Supreme Court is not talking about the merits of the case. They're basically saying, yes, there is a cause of action. Retaliation is not just to protect the employee that files the claim. It is also to protect a third party connected to that employee. And I think it makes perfect sense from a policy standpoint, but it is a relatively recent case, and I think it's important to note it. This is the place where we would have been had the projector been working correctly last class, but this was a meaty chapter. And I wanted to give it time, and I wanted to go through it properly. Some of you were late in coming in. The point that I want to make, when we suffered through before spring break without a projector, when the audio of that tape is loaded onto YouTube, it will have the slides being displayed. So even though we didn't see it when we were here, if you want to listen to the lecture again, you will actually see the slides when you listen to it. So for what that's worth. All right. Now we're going to switch gears altogether. What we're going to start talking about today going forward and next few classes where we'll actually slow down the pace, we'll only have a couple of chapters for the next few classes, is we will talk about different types of business entities. Okay? Different types of business entities and the advantages and disadvantages of setting up a business as a small business, as a sole proprietorship, as a partnership, as an LLC, as a corporation, looking at the attributes of each of these different types of businesses. Okay? And today, we will easily get through this material because all we're covering are sole proprietorships and partnerships. Okay? And a lot of these chapters become pretty redundant when we start talking about advantages, disadvantages, right? After all, this is business law, right? We've got to understand how businesses are set up and the legal implications of that, right? The legal implications of that. So, capitalism based on entrepreneurship, right? Based on small businesses driving the economy, so on and so forth. And frankly, most businesses in the United States are small businesses. The vast majority of them are based on somebody coming up with an entrepreneurial idea. I mean, they don't all morph into an Amazon. They don't all morph into a Yahoo. They don't all morph into Facebook, right? But remember, a lot of these mega companies were, the ideas and the framework was laid out very humbly. But putting that aside, a lot of people run their mom and pop operations. There are a lot of, corner dentists and, retailers and shoe shine places and bagel joints and all of these sort of places that are small businesses that not only fuel the economy but provide employment and pay taxes and do all of these things that, again, make our capitalistic little economy plugging along, right? So yeah, an entrepreneur is someone who operates a business either by himself or along with others, whether it's a partnership or an LLC or simply someone that hires employees to help him or her run a business. And in this slide we'll talk about, as we sort of depict all of the different types of ways in which businesses can be set up. Sole proprietorships, general partnerships, limited partnerships, limited liability partnerships, limited liability companies, and as we get more sophisticated, corporations, whether they're C corporations or S corporations. And we'll see that it really is an evolution over time, because if you guys looked at this and somebody was thinking about starting their business, what would you most be attracted to and why? Say that again?
I would say that's individual maybe.
Sure, and I can see business reasons why. What would a lot of businesses want to morph into over time? Somebody raise their hand, so I call on someone. Yes? Why? Why an LLC? I know I'm stealing my own thunder for later chapters.
Because you have liability and that person will be responsible with your personal assets to the company and debts. So you only need to do the amount that we invest.
So the point being made is a very valid point, although it is easier to just be a sole proprietor and it takes all the hassle out of it. Liability, yes. Say that again?
You don't have the double taxation?
Yeah, so tax reasons could be one of the reasons as well, but you don't have double taxation in sole proprietorship either. Right, but you're doing a corporation, yeah. So what I'm hearing is, and that's sort of the one we talk about, well, it would be easier to be a sole proprietor. If I'm just setting up a business, I'm right with you. But on the other hand, I want to start to look at my choices and say, where can I get liability for my personal debts and potential wrongdoing? And number two, where can I make sure that the income that I generate from my business is not taxed twice, and so on. So tax consideration, liability considerations, ease of business, and so on. And I say it's an evolution because limited liability companies are relatively new. The ability to set up a business as a one-person LLC is relatively new. It wasn't an option 40 years ago, 50 years ago, right? So yeah, but the reasons why the law has evolved and the reasons why people want to constantly think about pros and cons are the very reasons that you have just mentioned, and that's what we'll sort of think about as we talk about the attributes of a lot of these things. Okay. Sole proprietorship, easy. Not that running a business is easy, but at least the structure of how you're running your business is easy. Why? Because the owner, so when I say sole, I mean a single owner. The owner of the business is actually the business. I mean, there's no difference between me running my business versus the enterprise that I set up. That has advantages of simplicity. There is no separate legal entity. So the advantages sort of define themselves. It's easy to form and low cost. Maybe if I'm running my business under a different name, I set up a bagel shop and I call it Best Bagels in Town, I might have to file a DBA or doing business as with my local county clerk's office or something like that. But really easy, low cost. I like control. I get to make all management decisions. I don't have to go to a board of directors. I don't have to worry about my partners. I don't have any, right? That's good. And here's the thing. Why set up a business? I want to be profitable. And guess what? I get to keep all my profits. I don't have anyone to share it with. I don't have shareholders. I don't have any of that to worry about. And to the extent that I build up a very successful business, or to the extent that I get tired of it, I'm able to very easily transfer it, sell it, dissolve it, do whatever, right? So yeah, I see a lot of advantages to running a business as a sole proprietor, right? But got to look at the flip side too, right? I mean, this is this is not a one-sided sort of a thing. Sole proprietorships also have disadvantages, and the primary, two big disadvantages. The first one is, in order for a business to be successful over time, is you have to infuse capital into it. So if you're a sole proprietor, what are you limited to? What the money you have or the money you can borrow, right? If you're not going to let in a partner, if you're not going to let in shareholders, what is your other source of capital? So you can only be so big. Right? At some point, the sole proprietorship, in order to grow, might have to think about what to do next, right? So that's an obvious disadvantage, but a lot of businesses start off as a sole proprietorship. But the other big one, I would put a star next to the other one, is the fact that you, the owner, are legally responsible for all activities of the business. And that is the problem with having unlimited liability. Right? What if someone slips and falls? What if you set up a business and you're running a medical practice and you conduct malpractice, or you're sued for malpractice? Sure, you could buy malpractice insurance, but it'll cover you up to a certain point? What if you're sued for negligence beyond what the, again, there is no difference between the owner and the business. So what that means is everything that you put up for the business could be gone because of a single act of negligence. But beyond that, your personal assets, your house, your car, your yacht, everyone have a yacht, I'm sure, could be, because there's no difference. You haven't set up any legal fiction between business and your business self and your individual self. So perhaps the biggest downside is the fact that there is unlimited personal liability. But again, no formalities, very little, if any, federal or state governmental approval. By the way, anytime we start on a new area of the law, I always say state law or federal law. If you're setting up different types of businesses, even if you're setting up a corporation or an LLC, leaving aside the tax implications, because I know we all file federal income taxes. We're talking about state law. We're talking about incorporating, setting up under the laws of particular states. Okay? So keep that in mind as we start talking about this area. So just to sort of show you what personal liability looks like, if I'm a sole proprietor and I owe money to a third party, right, because I borrowed money from them in order to put capital investment into my business, if I default on that loan, it's not just the business assets, I have personal liability. I will have to pay that off. I may go bankrupt as a result of it, unfortunately, because there is no difference between me as the owner and as the sole proprietor. Okay? Yes? Don't have, what's that? Yeah, like doing businesses. I mean, I think that that point is overstated because, again, I may not have to. I may just be doing, business under my name and so, I don't have to. But anytime you're doing business under a fictitious name, you at least have to file a DBA or doing business as. So you're right. There may be very minimal filing involved. I think the slide overstates it a little bit because even as a sole proprietor, you may have some minimal filing obligations, but it's nowhere near what it would be to file articles of partnership or articles of incorporation or things like that. Okay, the only case in this textbook was a case involving a sole proprietor that set up a scone shop. How nice. Who doesn't like scones, right? What happened? Someone I may not have heard from today. Is anyone itching to talk about this case? Kim.
This woman owned a stone store, whatever, and under as a sole proprietor, she had it in her name. And she took out a line of credit with the bank and paid it for 4 years. And then after 4 years, decided she wasn't going to pay it or couldn't pay it or whatever the case might be. During that 4 years, though, she changed the sole proprietorship to legal liability and tried to claim that she wasn't legally liable because she was now an LP.
Or LLC, I forgot, whatever, yeah.
But the bank said, well, we gave you this loan when you were a sole proprietor.
Right. And the court agreed. Yeah. So here the case was an interesting case, sort of your point, well, you set up a business as a sole proprietor, but over time, you sort of wake up and say, hey, I'm getting successful or I'm incurring debt or whatever the case might be. I want to become a limited liability company, and you set up a limited liability company. But the problem here was the loan that she took out earlier was when she was still a sole proprietor. And it was a $100,000 loan or something like that, and there was like $95,000 still remaining to be paid, right? So she goes out of business and she says, I'm not responsible. The capital of the store is all you can go after, and the court says no. This loan was taken out when you can't convert debt that was taken out when you were a sole proprietor and just say because 2 years later I became an LLC, that debt magically goes away. No, I mean, anything that you take out as a limited liability company going forward is one thing, but not going backwards. Why? Because the bank lent out money based on who you are as a credit risk, not just the business, but who you are personally as a credit risk, and you cannot erase that. And it's it's a simple takeaway, but it's an important point to make. Yeah. To the Supreme Judicial Court of Maine? Yeah, I agree. I wonder, the only thing I sometimes say is that we don't have, we don't have the full decision. We have a snippet of the case, and there might have been other issues involved. And all we got was the holding on this one narrow issue. Because this is, in 2010, the concepts of limited liability are fairly drawn. There's plenty of precedent. Why is the case going through the appellate court level and all the way up to the state's highest court of Supreme Court? Seems ludicrous. As someone who has to reasonably justify it, I would say this was one narrow holding of the case, and there must have been other issues involved. But the application of this point is pretty fairly settled. I mean, this case is 1972, I would understand, but 2010? To say that your liability as a sole proprietor is something that flows to you through unlimited liability, you don't have to be a judicial, genius to figure out that would be the holding in this case. I just think that there were more other issues. But still, for all us learning the area, I think it's an important point to bring this about. All right, everyone can, you guys are all future accountants, auditors, you worry about income tax consequences, of course. And you know that as a sole proprietor, there are no taxes that are being paid at the business level, right? So to the extent that a business is profitable, those profits are taxed once. Earnings and losses are reported on personal income, on the 1040 of the owner themselves. But of course, income tax returns are filed both at the federal and the tax level, but income, and there's this notion of flow-through taxation. So, right, what is flow-through taxation? Flow-through taxation is when taxation flows through the individual. And that applies, as we'll see, with partnerships as well. Whether there's one owner or a single sole proprietor, to the extent that the business is successful, or the business is unsuccessful, profits and losses are reported on the owner's income tax return, and hence the notion of flow-through taxation.